Hi everyone, this is Maria reporting from Los Angeles, California. Today is October 11, 2012, as we can see Governor Romney addressing the public. Topic for today is waiting time penalties. Let's see the opinion of Governor.
Good morning to all fellow Americans, and today I want to talk about waiting time penalty law. Public policy in California has long favored the full and prompt payment of wages due an employee. To ensure that employers comply with the laws governing the payment of wages when an employment relationship ends, the legislature enacted Labor Code Section 203, which provides for the assessment of a penalty against the employer when there is a willful failure to pay wages due the employee at conclusion of the employment relationship.
He is so boring.
Assessment of the waiting time penalty does not require that the employer intended the action or anything blameworthy, but rather that the employer knows what he is doing, that the action occurred and is within the employer's control, and that the employer fails to perform a required act. Assessment of the penalty is not automatic, however, as a good faith dispute that any wages are due will prevent imposition of the penalty. In order for the penalty to apply, there must be a true employer-employee relationship and a quit or a discharge, which includes a layoff.
I want to sleep now.
The penalty applies to the willful failure to pay any wages, which refers to the definition of wages in Labor Code Section 200. Thus, all compensation must be considered in determining if all wages due were paid as prescribed by law. Wages does not include expenses. In calculating the penalty, overtime wages are considered only if overtime is regularly scheduled each week. Occasional or infrequent overtime is not considered in the calculation of the daily rate of pay for purposes of computing the penalty.
Wait, Governor, everyone will sleep now, so I want to crack a joke.
Sure, beautiful lady.
I asked God for a bike, but I know God doesn't work that way. So I stole a bike and asked for forgiveness. Another one: the last thing I want to do is hurt you. But it's still on the list. And the last one for sexy governor: if you think nobody cares if you're alive, try missing a couple of payments.
Woo!
Does the waiting time penalty apply to part-time and temporary employees, or just to full-time employees?
The waiting time penalty applies to all employees regardless of status, exempt, non-exempt, full-time, part-time, temporary, probationary, or otherwise. The penalty does not apply to independent contractors or volunteers, as they are not employees.
My employer failed to pay me my final wages within the time period prescribed by law, and I believe I am entitled to the waiting time penalty. What can I do?
You can either file a wage claim with the Division of Labor Standards Enforcement, the Labor Commissioner's Office, or bring an action in court against your former employer.
When computing the amount of penalty, do you count only the days I might have worked during the period for which the penalty accrues, or do you also include all non-work days?
All non-work days are included. When computing the penalty, you count all of the calendar days for which the penalty accrues, including weekends, non-work days and holidays.
Thank you, Governor, and this brings the end of today's episode of Waiting Time Penalities Law. If you like it, share the YouTube video to spread awareness. Enjoy and God bless America.